Welcome back to my channel. If you are new here, welcome. My name is Sharon, and on this channel, I would like to share with you summarized study notes on the various SQE topics that I am studying. These notes, as I post them on here, help me reset the information I am learning so I can retain it. I am hoping that these study notes can be of beneficial use to you on your study path on the SQE. Please remember, this platform is only for sharing of knowledge gained through study and a place to interact with other students. You must read further and deeper on each SQE module. On this channel, we gather and support each other to study and learn. These notes are my own that I have put together through my own study. If you have any constructive comments and/or information that you would like to share with other fellow students like myself on here, please place that information in the comments section below. Don't forget to like and subscribe to my channel, as I will continuously post on the various SQE modules as I am studying through them. I look forward to engaging with you. Elements of liability. A criminal offence requires a physical act which is referred to in the Latin phrase actus reus, as well as a mental state called mensa rea in Latin, to occur at the same time. An example of an offence that requires just the act and not requiring any mental state is called a strict liability offence. An omission to act does not mean a basis for a criminal offence. Bear in mind, though, that an omission to act by a person with a duty to act and failed to do sufficiently will have breached that duty, and that omission is culpable conduct. So when can a duty be imposed? The following would apply. By statute, close relationship like a parent, child, doctor, patient. By contract, for example, between a railway, its guards and its passengers, the defendant causing or creating the situation. So in essence, you are not required by law to help anyone unless you have a duty to act. There are certain situations that must exist for there to be a criminal offence. For example, a defendant commits a criminal offence when they damage someone's property. If they damage their own property, then it is not criminal damage. A crime based on a result, such as murder. Murder requires the victim to die. The defendant must have caused the result, that is, of the victim dying. Here, the law says there must be two tests that need to be satisfied. These are, but for test. This means that the result would not have happened but for the defendant's actions or conduct. What about mens reus? The mens reus for a number of crimes is intent, which can be satisfied in two ways. These are direct and indirect intention. What is the doctrine of transferred malice? If I, as Miss Legal Eagle, being the defendant, had an intention to commit an offence against A, but inadvertently I commit that offence to B, the intent is now transferred to B, and the mens reus requirement of that offence will be satisfied. Please also note that in this situation, the defendant can be charged with two offences. The first being the completed offence against B, and the second being the attempted offence against the intended victim, who was A, crimes of recklessness. These result from the defendant having subjectively foreseen the risk from the act and continued regardless. Crimes done negligently are those where the defendant owed a duty of care and where the defendant breached offences under the Theft Act. Theft is where a person dishonestly acquires property belonging to another with the intention of keeping that property, thus deriving the owner of such property of it. Appropriation occurs when some of the rights of such property are taken with the intention of being dishonest. So say, I take some chips from someone's plate in a restaurant without you knowing, or when your back is turned, that would be appropriation, as my intention was to be dishonest. Proof of robbery. This requires proof of theft and use of force to take property which puts the victim in fear. Now let's look at the act of burglary. Burglary will involve two things. The defendant must have entered a house, or other buddling, for example, as a trespasser. Even if the defendant merely put their hand through an open window or put their foot through the doorway when the door had been left unlocked. The second way to commit burglary would be if you entered a building with the intention to do the following: cause criminal damage to the property, steal anything from that property, or inflict grievous bodily harm on anyone who is in that property. We call this burglary by trespass with intent. When the defendant has now entered the building, we then say that the defendant actually stole or tried to steal or inflicted or attempted to inflict grievous bodily harm on anyone who was in that property. In criminal law, we call this burglary by offence following trespassory entry. Do you see the difference? You can replay this bit again if you have not quite got it the first time until you are singing it in your sleep. Aggravated burglary. Let's say I break into your house which is committing burglary, and in the process of doing so, I brought crowbar, a knife, a gun, even if it was an imitation gun, with the intention of harming someone. That would constitute aggravated burglary. What are homicide offences? The crime of murder needs there to be proof that A caused the death of B unlawfully, and with the intention to kill or cause grievous bodily harm. So, let's say that prosecution proves the elements of murder. Can the defendant raise any form defence, or can there be some form of defence that the defendant may raise? Yes, there can be such defences, and these are diminished responsibility and loss of control. Such defences could reduce the offence of murder to voluntary manslaughter. Please go and do some further research around these two defences. I have only just touched the tip of the iceberg here. So I have mentioned voluntary manslaughter. What about involuntary manslaughter? This is when A kills B, without the intention to kill them or to inflict grievous bodily harm. This could result in liability of involuntary manslaughter. There are two types of, and these are unlawful act manslaughter and gross negligence manslaughter. Assault. This is the application of unlawful force. This does not always have to be physical force or require that the victim is touched in any way. Words used on their own can be enough to warrant assault if the victim believes that violence is imminent. On the flip side, some words can water down the imminence of this violence. I will give you a scenario to clarify this a bit more. Say, I walk up to you and I am pretty angry and I say to you, Joe Bloggs, I'm going to hit you in the face with this bottle. This is assault. However, if I said, Joe Bloggs, I would hit you in the face with this bottle if it was not against the law. This would not be enough to warrant assault, as the words used watered down or toned down that imminent threat. Got it. Good, well done. Let's move on to discuss and learn about fraud. Fraud by false representation is when a person dishonestly makes a false representation with the aim to gain for themselves or another party at the detriment or to cause loss or deprivation to another. Other fraud can be fraud by failure to disclose and fraud by abuse of position. Criminal damage offences. This can occur if you destroy or damage property that belongs to someone else without lawful excuse and being reckless as to whether that property is destroyed or damaged. Please note that the property that is damaged must be physical property and fungi and plants are not included. A defence for criminal damage can be that there would have been consent to break the car window, to rescue someone in that car, or having to destroy someone's property so that you can protect yours, could be used as defences. Aggravated criminal damage is similar to criminal damage, differing in that the property can belong to the defendant alone. Please note, however, that the defences that I have referred to for criminal damage are not applicable for aggravated criminal damage. As always, I do urge you all to please read further around this to gain comprehensive, all-rounded knowledge. Are you still with me? Remember that when studying, it's important to take breaks, so please feel free to pause this video and go for a stretch or a walk, but do come back, of course. I will be waiting to continue where you paused me. If some of you that are still here and want to continue, let's soldier on. Now let us discuss parties to a crime. Principal offenders are when two or more people get together to commit an offence. They may be tried as principal offenders. I want you to remember the following acronym: CAAP. This means anyone who counsels, abets, aids. Procure another into committing a crime may also be charged as a principal offender. Remember that old saying, partners in crime, inchoate offences or incomplete offences. This is when a defendant is guilty of attempting a crime if they do not complete the crime, but do something more than merely preparatory towards its commission. For example, if A decides to buy poison to put into B's dinner to kill B, this is merely preparatory. You are planning it and have not actually done anything. However, if you then place the poison in B's dinner and B does not die, maybe B decided to skip dinner, or B ate the dinner, but the poison failed to kill them and they survived. This would be sufficient for attempt, as it was much more than merely preparatory. Can you see the difference with these scenarios? The final topic under criminal law that I am going to discuss with you is criminal capacity and defences. I will start with asking you a question. In the United Kingdom, what is the age of criminal responsibility? Or at what age can you be considered capable of committing a crime? Okay, I will tell you if you are unsure. A child under the age of 10 is incapable of committing a crime. A 10-year-old is considered old enough to commit a crime. Other defences of criminal capacity are as follows. Self-defence. Involuntary intoxication. Intoxicated by no fault of their own can be a defence if it stopped the person from forming the mens rea of the crime charged. Unfit to plead the above is not an exhaustive list. Please go and read further on the circumstances where other criminal capacity defences can be upheld by reading on voluntary intoxication after taking prescription medication, use of force that is grossly disproportionate, necessity and duress. Non-fatal offences. Against the person assault is an offence where person A recklessly or with intention causes person B to be the recipient of or apprehend immediate application of unlawful force. Remember too that person A need not even touch person B, but the words that person A may say may to person B are sufficient for person B, the victim, to believe that there may be violence. Words can also negate the imminence of violence. So, if I approach you and I say that I am going to hit you with a baseball bat, that could be taken as assault, as you are fearing that I will hit you with the baseball bat. However, if I was to say that I would hit you with a baseball bat if it were not illegal, then the words I used negates the threat and it is not assault. See the difference words make? Anyway, please don't threaten anyone under any circumstance. Are you all still with me? Great! So, what is the offence of battery? This is when someone intentionally or recklessly applies unlawful force on another person. In everyday life, in the day-to-day routine of life, we give implied consent to touching or contact that can happen, and this would not be termed as battery. So, consent can be used as a defence to assault and battery. Aggravated bodily harm, known as ABH, is when person A calculated to cause hurt and injury in such a way that it will affect or interfere with the health or comfort of another. The offence of S20, which is wounding or causing grievous bodily harm, will require proof of intention to cause some harm or recklessness in causing some harm. This harm must be greater than that of actual harm. An example would be stabbing someone with a knife that results in a wound, and the intent is to cause some harm. Let's go back to consent again. Consent can be a defence in some circumstances, such as, I will name a few: religious practices like circumcision, sport, contact as long as it is within reasonable rules of the sport, surgery. Can you think of any others? Research a bit more and you will find others. So this brings us close to this very summarised overview of our study on criminal law. It really helps me learn and prepare for my SQE 2 when I go through these notes again to keep recapping everything. I hope as you study and learn with me, together we will learn to retain and recall information that will be extremely helpful in studying for the SQE exam. I look forward to you joining me in the next session. Remember to subscribe to my channel and hit the like button so we can continue to engage and draw others to our student platform to learn along with us. If you have any comments or other useful study points on the topic we are looking at that could help other students, please make sure to post it in the comments section below. Till the next post, let's keep reading wide and well.